You're welcome back, and you're still watching Newsnight live from Nigeria's capital in Abuja. I'm Christian Ogodo.
I am Adesua Omorwan.
Counter directives on the use of the old 500 and 1,000 Naira notes as legal tender have led to controversy and uncertainty. Let's cross live now to Delta State to speak to Epiphany Azinge. He's a professor of law and a senior advocate of Nigeria, as well as being a former Director General at the Nigerian Institute of Advanced Legal Studies. Adesua, you want to fire the first salvo?
Thank you so much, Senior Advocate of Nigeria, for joining us on the news tonight. We do appreciate it. It would seem as if some governors are daring the president's directive and, by extension, daring the president. But I think a good place to start would be to ask you, who determines what is a legal tender in Nigeria? The Central Bank of Nigeria, the courts, or the governors, such as the likes of the governor of Kaduna State, El-Rufai, who insists that the 500 and 1,000 naira denominations remain legal tender?
Well, I think you have fired several salvos at one stretch, and we need to dissect and address each and all of the aspects of the question. Firstly, there is a law that determines what is a legal tender, and that is the CBN Act. And to that extent, the policy directive flows from the central bank in that particular enactment. Secondly, is that we're aware of the fact that even if there is a dispute arising from the interpretation of a particular enactment in that regard, it is the prerogative or the duty of the court so to do. And in this regard, it would appear that the Supreme Court seemed to have weighed in to an extent, even if not conclusively. And the challenge, and that is the worrisome aspect of it, is that even without coming to a conclusion, a presidential address was obviously ensued, and that led to the constitutional crisis we seem to be having at this point in time, with the pronouncement that followed from Governor Nasir El-Rufai. Well, there are issues that we must have at the back of our mind in trying to look at some of these issues, and they are namely: one, the Supreme Court made a pronouncement and obviously may not have concluded on that, and that has been deferred till the 22nd of this month. The president followed with a speech, and what could be said of the speech of Mr. President is that automatically, as the chief security officer of the nation, the president, commander-in-chief of the armed forces of the Federal Republic of Nigeria, at the time this president spoke, there were already signs of breakdown of law and order. There were protests in so many parts of the country at that point in time. And one that means well as a president definitely will want to make statements that possibly will contain the breakdown of law and order. And to that extent, it was well intended that Mr. President spoke when he did. But would he have gone further to make some policy statements as regards the Naira swap and obviously the dates for determination, as the case may be? Possibly not, but even at that, he had the other overriding consideration of public peace, as the case may be. Now, would it have warranted a counter pronouncement from Governor El-Rufai? I believe that the answer is categorically no. Not at all. Not at all. Well, not in a presidential system and not in a federation where the power vests, executive powers vest in Mr. President, and where the issue at stake has nothing to do with anything within the gamut or the framework of the concurrent legislative list, which is the operational consideration of a governor. everything about the exclusive legislative list as far as foreign currency and other issues are concerned, minting, are all in the exclusive legislative list. And to that extent, within the gamut and the purview of Mr. President. So for Mr. President to make such pronouncement, yes, it is within his own power so to do. But for there to be a counter pronouncement from Governor El-Rufai, I believe that was going too far, and one that is capable of causing constitutional crisis, and one that should not be encouraged in any manner, and I believe that it was not in good faith. What could have been done if you imagine that the Supreme Court made a pronouncement and you wanted the matter to go further? You know what to do. You have lawyers, you have your Attorney General, you have to return back to the Supreme Court to make a case that this matter that you ruled upon, that the federal government is disobeying that particular ruling, and what can be done. It is at that point in time that you will either determine whether there is an officer, since Mr. President enjoys immunity, is there an officer of the federal government that can now be cited for contempt for encouraging Mr. President to go further. It is not for you to take powers or right into your hands to counter the pronouncement of Mr. President. I believe that was totally condemnable and should not be encouraged in any way.
In fact, some Nigerians are even saying it's treasonable, you know, depending on the divides that they belong. But the question really is, what's the way forward? You, as a senior advocate of Nigeria, a professor of law, a former director general of the advanced Nigerian advanced legal studies, domiciled at the University of Lagos. What, in your own, with your residual knowledge, what would you be telling the president? What would you be telling the nation, you know, in this matter?
Well, I will tell the nation that 22nd of February is almost by the corner. It's just next week. And that we should be patient enough to wait for the conclusive pronouncement from the Supreme Court on that day. And maybe the matter will be heard and the ruling be given, or judgment as the case may be, on that particular day. We should be patient for that. Secondly, we should also realize that the president meant well or means well for the nation, and so we work with what we have at the moment, the 200 Naira notes, but there must be a way that the central bank must be pressurized or compelled to make sure that more money is pushed into the public domain. At this point in time, we are all witnesses to the suffering and the chaos, the anarchy, and every other thing that has followed this Naira swap policy. I don't think it is going well. It could have gone better, but typical of the Nigerian situation, we always wait for the last moment. But even at that, I feel strongly that a little bit of patience. Let us tarry a while and see what happens come the 22nd of February next week.
Senior Advocate of Nigeria, let me ask you, because the Naira notes or the Naira denominations in question have not only lost legitimacy, but street credibility and acceptance, as I like to describe it. A lot of Nigerians, and reports we are getting across the country, are not even collecting these monies anymore. I doubt if the Supreme Court will even accept to collect these denominations for filings of proceedings. So why are we fighting over it? And explain to us the legality here. The governors are screaming contempt of court by Mr. President, yet they are not suing the CBN, who is the owner of this policy. Does that make any sense to you, Senior Advocate of Nigeria?
Well, this is an area that I may not be in a hurry to dabble into for obvious reasons, because it is not in my character to scrutinize pronouncements of the Supreme Court openly, as the case may be. But having said that, there are so many other considerations. Why was the central bank not made a party to the action? amongst others? Could it be that if they've done so, maybe they will lack the jurisdiction, the Supreme Court will lack jurisdiction, because the Supreme Court can only have original jurisdiction in matters between the states or between the states and the federation, and certainly not corporate entities or agencies of government, as the case may be. Could that be the reason why, instead of going to the Federal High Court, where the central bank would have become a party, they opted to go to the Supreme Court because they wanted to sideline the central bank, as the case may be? But the absence of the central bank in that particular dispute, it also means that obviously they were not a party, and to that extent, technically one can argue that the decision or the pronouncement of the Supreme Court may not be binding on the central bank. But as far as we know, the Central Bank Act is clear. Issues of legal tender, the CBN has the last say, and that is not in contest. So how we can rigmarole and wriggle out of this controversy is a totally different kettle of fish. But the issue of legal tender, it is within the purview of the central bank, and they have the powers by the Central Bank Act so to do, and their pronouncement should be considered very weighty in this circumstance.
Well, no better place for us to really drop the anchor here. Senior Advocate of Nigeria, former Director General, Nigerian Institute of Advanced Legal Studies, and Professor of Law, Epiphany Azinge, speaking to us from the Delta State's capital in Asaba. Thanks for being part of Newsnight.